Please, will you hand me my screen box?
Okay, so we are not on the record because this is the first hearing. And so, counsel, what is happening here?
Thank you, Your Honor. I did speak to the defendant, and she indicated to me she had some repair issues. I asked her to send me a list of them. And she also indicated there were some other issues with maintenance personnel. I've asked her to send me everything just to short circuit this. I would ask for an escrow order here as well, since she's alleging maintenance issues.
Excuse me, Your Honor.
Okay, yes, Ms. Price, I was going to give you an opportunity. I was just waiting for Ms. Luckoff to finish.
Oh, okay,
All
absolutely.
right, that's right. Ms. Luckoff, are you finished?
Yes, I am, Your Honor. Thank you.
Okay, all right, thank you. Okay, and Ms. Price?
Yes, I did also mention that I've also dealt with a rodent issue since May, and I've been calling them nonstop, whether on the hotline or whether actually saying something. And the only time someone came to my apartment was to lay down a paper trap, and then I got that. As I explained to Ms. Luckoff, received multiple inappropriate texts from the maintenance manager, and then a snide remark talking about, haha, watch out for those mice.
Okay, and you still have that message?
I have all the messages, all the pictures of rodents, the fecal matter. I've called the actual city of Riverview about it. I've actually called for an inspection as well, because it got to the point where I put my daughter down in bed and it was crawling in her bed with her. And she has
And Your Honor, the problem is, and I'm not in any way, I have no basis to say either way, but I asked if there were written work, submitted through the portal, and Ms. Price said no. She said she didn't have access to the portal. So obviously I want to look into all this, and that's why I'm asking, well, obviously the case will be adjourned anyways, but I asked her to send me a list of everything and any pictures she wants me to look at.
Okay, and so what is the amount that's due and owing right now?
$1,300. She's also disputing that as well, but that's what our records show.
Excuse me.
Okay, yes.
She said it was $1,250. Frankly, Your Honor, I don't care if we could do an escrow order for $1,250. That's not what I'm going to die on right now.
Okay, all right, yes, Ms. Price.
Yes, because I've had the issues and the complaints, I know I have been doing some research, and I took it upon myself with working with the city of Riverview or just getting some type of information. I was also able to find out that in order to do this, they have to have a certificate of compliance. And they told me, and it's right there on the city of Riverview website. And I even asked them, like, can you give me this information? Do you have any of this information? Can you help me? And they would hang up the phone or laugh at me and then hang up the phone. And I feel like that.
I find that hard to believe.
Hold on, please, hold on. Who's they?
I'm sorry?
You said they would hang up the phone.
Yes, so if I was calling, and I have the phone number that I've only been calling, the 855.
I know, but ma'am, Ms. Price, I'm just asking, who is it? Who are you referring to that you would call and you would be hung up on?
I would call the after hour hotlines, because I explained to Ms. Luckoff, I work from 7
for the apartment
7
complex?
p.m. Yes, correct. I was calling the apartment complex.
Okay, I wasn't sure if you were I just want to be clear who you were talking about as far as they would hang up. Okay.
No,
so,
I'm sorry.
That's okay. So let's set this for November 17th at 10 a.m. I'm going to order escrow order to enter. And so Ms. Price, you have the money set aside for the month of October?
Yes, I do. I've been collecting it, and I just needed some assistance and some help. And I feel like I should never have to take this far of measures of withholding my rent to just somebody come fix my apartment or to take care of the rodent situation.
Okay, so an escrow order is going to enter, which means you're going to deposit your rent payment here at the court. So for the month of October, and it would be $1,250, right? That's your monthly rental
Correct.
amount? Okay.
Reading that, Your Honor, just for ease of today, I'm saying the $1,250. Okay, because I believe it's $1,300. I'm just saying.
It's actually, Your Honor, I have a paper here I have a paper here with my original information and the person who signed my lease, Mr. Teddy Hall. My original paperwork from when I first signed in on February 1st. And I have actual email messages where he said he messed up on my paper. And I said, we both agreed it was $12.50. He said, yes, we did. He actually sent me an email once I corrected him on that.
Okay, so you need to make sure you're getting all that to Ms. Lugoff so she can review all that, okay?
Okay.
And so
Absolutely.
for purposes of the escrow order, we're going to indicate $1,200 per month for the escrow order. And,
Wait,
November
1250, Your
17th.
Honor? 1250? That's what she's saying.
Yes, what did I say?
Oh, I think you just said 1200.
Oh, I'm so sorry. I'm looking and reading 1250. I don't know why I said 1200. $1,250. Oh, maybe I didn't say the $50 after that. $1,250. And so ma'am, you'll have to pay your October rent at the court as well as your November rent.
Okay,
Okay?
absolutely.
All right, and we'll see everybody back on November
sorry.
17th at 10 a.m. And please make sure that you are communicating with Ms. Lugoff with all the data that you have, okay?
Absolutely. What's the address to the court? Or I can find it online, correct?
Yes, it's 2015 Biddle Avenue.
2015 Biddle Avenue.
Yes, and why not?
Avenue. Okay, thank you.
You're welcome, thank you.
Uh-huh. Have a good
Okay,
one.
have a good day.
You too,
All right.
thank you.
This is 22-1717 SM, the People versus Thomas Montgomery. Can I get appearances?
May I please, on behalf of probation? May it please the honorable court, Delamugni, P number 85374, here on behalf of Thomas Montgomery. Tom, please say your name for the record.
Thomas Montgomery.
All right, so we're here today for a probation violation allegation. This is a fourth technical violation, which means you could get the full jail time on this case. At this point, I'm not limited in any way in the amount of jail time you could get. You could get the full 90 or 93 days on this, minus whatever you've already served. Do you understand that?
Yeah.
Yes, Your Honor.
All right, the allegation is that you failed to attend Badaver's intervention as scheduled and were terminated from the program due to absences. And then there's also the show cause fee assessed and a balance of $435. You understand the allegation against you?
Yes.
Counsel, did you go over your client's advice or rights form with them?
Yes, Your Honor, we did.
And I have this signed and date advice or rights form here.
Yes, that's correct.
Okay, so how is your client proceeding with respect to this allegation?
So, Your Honor, we would love to accept responsibility for any violation that had occurred, but at this time, I think it's in his best interest to stand mute.
Okay, well, I'll enter a not guilty plea on his behalf. And we're gonna hold a hearing then?
Well, I'd just like to say a few words. I know that Matt had given his recommendation. We're okay with it, just minus one term. So if we could have a moment to discuss what that is with you, Your Honor, you can make that final decision.
Do you know how many times this guy's been in front of me for violating his probation?
Yes, Your Honor, I'm aware.
Okay, he's a problem.
Right.
And I just had to give him a few days in jail not that long ago. And he will not comply with court orders. Like, quite frankly, before you start allocating on his behalf, I want you to understand, or allocating on his behalf, I want you to understand that I think this is generous. Because if Mr. Keys would have wrote terminate probation, revoke 7694A, and give him 93 days in jail, I would have found that to be an incredibly reasonable recommendation. So I want you to know that before you continue. I think that this is probably about the most lenient recommendation I've ever seen by Mr. Keys. But go ahead.
So, Your Honor, I completely respect all the things you told Thomas and I right here, and we very much so respect Matt for the recommendation that he's given us. Now, the only reason that I have any issue with it is the 1 day in jail. And I know you probably want to cut me off and scream at me, but today I'm not just standing in front of you as Tom's attorney. Today I'm standing in front of you as his childhood friend, somebody who I went to high school with, somebody who I played football with growing up. I know this kid personally. I know that at a human level, he's a God-fearing, hardworking, and smart kid.
Did you read the allegations? Did you read what he pled guilty to? Did you read the facts of this case? Okay, I just want to make sure.
And as a criminal defense attorney, and as you who worked in criminal defense, you know that just because people make mistakes in life doesn't necessarily make them evil. They're not inherently evil.
I agree with that.
And knowing Tom on a personal level and growing up with him as a kid and knowing who his family is, they are a well-respected family and they love him so much. They're here today in the stands. His father, his mother, and his fiance, the mother of his future child who was pregnant, all came out to support him today. Your Honor, I've had people who were being sentenced for heinous.
Who's the fiance or the girlfriend that's pregnant?
Could you please raise your hand to stand up to the court?
What, Your Honor? What's your name?
Brianna Lewis.
Your Honor,
The victim on this case. Okay, go on.
Your Honor, I've had people being sentenced for heinous crimes, facing years in jail, and zero family came to support. He's here for a probation violation, and his entire support system came out to see him. He has people who love him and care for him and will keep him in check. Your Honor.
And why did they make sure you went to these visits?
Sure.
I mean, like, he's got one thing he has to do. Like, listen, you pled guilty to a domestic violence with a particularly, in my opinion, egregious offense. It wasn't like you threw someone's phone at them. That's not what the allegation here was. And you had a very limited amount of things that I ordered you to do. And you got the benefit, sir, of not getting a criminal conviction on your record for beating on a woman. You didn't get a criminal conviction for that. That's the deal. You got this sweet deal from the prosecutor where you do not end up with a conviction on your record saying that you're a woman beater, and all you have to do is comply with what I asked you to do. And it wasn't like I set out some list of unobtainable goals. I didn't. Mr. Keys, can you find me I need you up here for a sec.
Yes.
Let's see, you had 12 months of probation. You couldn't use drugs, alcohol, or controlled substances, which you did. You've been violated for that. You weren't to have any assaultive contact with Brianna Lewis. I don't know of any of that. You couldn't have weapons or firearms. You had to keep a job. You had to go for treatment and follow recommendations. You had to, which you were already doing. This was something you were doing outside of what I just said you have to keep doing what you're doing, right? You were already seeing somebody. I said, you got to keep going. You got to keep seeing them. You have to go to batterers counseling. You have to do 5 days of community service. You had to get fingerprinted, and you had to comply with the payment plan. So literally, you can't have guns, you can't beat people up, you can't do drugs, continue going to your therapy, and go to this one class and do 5 days of community service. That's what I mandated. Does that sound reasonable to you, counsel?
It's completely reasonable.
It seems so incredibly reasonable, and he can't do it. He cannot get through this.
Yeah.
So, I mean, you can keep going, but if he's entering a not guilty plea and we're setting a hearing, the only issue we're discussing is bond.
Sure. So then how about this? At this point, we'd like to withdraw that not guilty plea. We'd like to accept responsibility for it, but I would like to continue to sort of help you.
Well, if you want to allocate on his behalf, I want to take the plea,
Sure.
and then you can go on.
Okay.
But I think I've expressed my frustration with him and his refusal to comply with the most basic of court orders. So, okay, sir, do you understand everything that's going on here today, Mr. Montgomery?
Yes.
You understand that it's your fourth technical violation, and I could give you up to 93 days in jail. There's a recommendation from probation that I not do that. Do you understand that?
Yes.
Okay. You understand all of these rights that you went over with your counsel on this advice of rights form?
Yes.
All right, and did you sign and take the back of it?
I did.
You understand if you enter a plea of guilty, you're gonna be waiving these hearing rights. There will be no hearing of any kind.
Yes.
We're not gonna have a hearing. Matt's not gonna testify that he talked to someone over at the batterers intervention place. I mean, we're not gonna call anyone in to testify. Do you understand that?
Yes.
And you'd be waiving the hearing rights. Your attorney's not gonna cross-examine them. None of that's going to happen. You understand all of that?
Yes.
How do you plead to the allegation that you failed to attend batterer's intervention as scheduled?
Guilty.
Were you terminated from the program due to absenteeism?
Yes.
All right, I'm satisfied with the plea. Go ahead, counsel.
Your Honor, I first of all, I apologize for riling you up a little bit. But as I was saying,
At the minute I saw what the violation was, I was riled up because I'm so sick of seeing Mr. Montgomery on the most basic probation violations ever, but go ahead.
well, this is going to be the last time you see him. And he promised me that. And typically, I can never come in as an officer of the court. I can never come in and advocate for my client, say that I know that this time is different because I don't know them. This is different. I know Tom. I've known Tom for a long time now. And to see him fall down this road, it's hurting me, but I know it's not him. And he wants to change. And the moment he walked into my office and the moment he looked me in the eye, he told me, Abdullah, I'm going to be a father. My wife is pregnant. My fiance is pregnant. I'm going to be a father. I want to turn this around for her. He said, I got a job at Avis now. He said, I work 5-6 days a week now. He said, everything I'm doing is for this child that's going to come into this world. He said, I'm on my way to getting health insurance. I'm 26 years old. I'm no longer dependent. I'm about to get my own health insurance. This is for my kid. If I serve any time in jail, I could lose my job, and that kid is going to end up going without the necessary means. Your Honor, I know you said a whole lot of things today about what he hasn't done, but I'll tell you what he has done. Sure, he's a struggling addict with alcohol and marijuana and other substances that he may not have disclosed to me, but he checked himself into NA and AA. Who does that? Who does that? How many people can walk up to you, Judge, and say, I checked myself and I know I have a problem. I know I'm an addict.
Is he going to meetings?
Yeah.
He has.
Are you logging them?
No, I have a sponsor. His name is William Moore. I've been going twice a week to the Salvation Army Center on Warren Road in Dearborn Heights.
For meetings?
Yes, for NA, and then I go to AA to virtual meetings.
Okay, show it to Matt. You're gonna have to start logging your meetings.
Okay.
All right.
So he's checked himself in something that I never see. I have clients that are severely addicted and they refuse to admit they have a problem. For anybody to come forward, regardless of what they've done in the past, and say, I have a problem and I need help is commendable. And I commend you for that. On top of it, as you stated, he's been meeting with his therapist approximately twice a week. She just gave us a letter. I'm not certain of the gender, but that person has given us a letter, which I have handed over to Matt, stating how far he's come. How far along he's come as a human being and as a person in general, and he's really on the right path. The path back to get on his feet and do the right things. Your Honor, he's completed all of his community service. Like you said, he's missed his DV course, but that ends here. The woman who runs the course told him, this is your last chance, and he said, that's all I want. Just one more chance to prove to myself, to prove to my fiance, to prove to my family, to prove to this court system that I don't want to walk back in here again. I'm going to go to every single course, and that's going to be that. But Your Honor, we beg of you. We beg of you. He made one mistake, and he takes complete.
No, okay. All right. I hear you. Listen. Here, is this the log, the absenteeism log? So he's been going to these classes since May. How many did he have to go to, Matt?
There's 26.
He went the first time. The second week he was absent. The third week was a holiday. The fourth, fifth, sixth, and seventh week he was absent. The fifth week was a holiday, or the next week was a holiday. The next week he was absent. He went to his first class on July 15th, and then he was absent. And then he went to second, third, fourth, and fifth class, and then he was absent, went to sixth class, and then he was absent again. Like, that's not really a good faith effort. This is what I'm going to do. And I cannot be more clear to you, Mr. Montgomery. You're about to be a father. You know what's really bad for kids to learn? That people hit their spouses. Well, how are you going to raise a child when you put your hands on that child's mother? Think about it. You know what you're going to raise? A kid that's a bully and a kid that puts his hands on women. Do you understand that? Do you understand that kids do what they see? So all I want you to do is go to the class I told you to go to. And you're gonna go to the class, because if you don't go to this class and you don't finish this class, you are doing 93 minus whatever days in jail. Period. Period. This is, if I see you one more time and it has to do with you missing these classes, period. That's it. Because the best thing I can do for you in this judicial system is try and help you become a better man by learning your triggers and learning ways to resolve your anger that don't end up with you putting your hands on that young woman. That's what we're going to do. And if you miss them and I hear from Matt and I see you again, bring your toothbrush. Do you understand me?
Yes, sir.
Don't bring shoelaces. Don't bring your phone, because when you come in front of me, we're going to have your little hearing and you're going right back there and you're going to Wayne County for 90 days. Yes, Judge, I understand, Judge.
Yes, Judge, I understand.
Good. I'm adopting the recommendation. I am proud of you for going to AA and NA. I mean, I think that's wonderful progress. But like, and I appreciate that. I run a treatment court. I think that's very important. But I'm not going to have you violating these orders when you got the benefit of not getting a conviction on your record. You should be thanking me every time you see me.
I do thank you, Your Honor.
Keep this. Don't ruin your life. Go to these classes. This is not an option. This is the most important thing in your life right now, is not seeing my face again. We're going to give him, when's probation up, Matt? Now.
It's December, I got to look at it, I want to say December.
It's coming up.
But
So I'm going to give him extra probation because I don't have a choice, because you want to be able to finish the program on time. So we'll extend probation by 6 months. You're going to continue with all previously ordered terms of deferred sentence. We're going to close once everything's been done, and I mean, there has to be some sort of sanction, right? This is all just saying, I'm going to give you more time to do it, and then I'm going to let you keep your status. What's the sanction? What's the punishment if he doesn't do a day in jail?
Electric chair.
Give us community service, Your Honor.
How is he done community service? Did he finish everything he had?
he has, he's finished community service.
He's got 24 hours of community service to be done within 30 days. That's your day in jail. And if it's not done, Mr. Montgomery, I'm tired of seeing you. If I didn't get that across to you, I don't know what will. I am not trying to be mean to you. I'm trying to make you understand you found yourself in the criminal justice system, and there are expectations that you comply with judges' orders. You're not the boss here. All right, we're all set.
Thank you, Your Honor.
Thank you.
All right, let's go on the record in the matter of the state of Michigan versus John Davis, 231970.
Good morning, Your Honor. Sarah Kraus. I'm standing in for the attorney of record, Gabby Silver, for Mr. Davis, who is also present this morning. Mr. Davis, can you state your name for the court, please?
John Kraus Davis.
All right, thank you. And today's the date scheduled for the adjourned probable cause conference. And counsel?
Yes, Your Honor. At this time, we are prepared to enter into a plea by the prosecutor's office with a sentence agreement to drug court. Mr. Davis has been through preliminary step for the 19th District Court Drug Court. They advised that he should continue with today's court date, enter the plea, and they asked for about 3 weeks until sentencing.
Okay, and would you like, did you already place the terms of the two charges that were amended on the record? I don't recall hearing that.
I did not, Judge. Mr. Davis would be pleading to an amended count 1, attempt police officer assaulting, resisting, or obstructing. And count 2 would be amended to operating while visibly impaired.
All right, Mr. Glenn in Wayne County Jail, please join breakout room 2. And Mr. Davis, please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
I do.
Sir, you're very muffled. I need you to please adjust where you're. Please let me finish before you interrupt me. Please adjust where you're holding your device, because I think it might. Please raise your device up from wherever it's sitting on. Okay. Do you sound, now can you please answer what you indicated?
Yes, I do.
You said- Perfect, much better, thank you. Okay. All right, and sir, you heard the very generous plea that your attorney worked out for you, correct?
Yes.
As to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Guilty.
As the amended charge of attempt resisting obstructing an officer, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
Was that yeah or yes?
Yes. Yes.
You also understand by entering into a plea, you'll be waiving some of those rights, specifically your trial and appellate rights.
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Please lift up your device again, sir. You're very muffled now.
Yes.
Okay, please stop setting it down. You also understand, sir, that in the event you are not accepted into the 19th District Court Sobriety Court, that your plea may not continue. Do you understand that?
I do.
Sir, please lift your device up again.
It is. I have it up.
Okay.
I haven't said that about it.
Well, I don't know if you're putting your hand underneath it or not, but every other time you're muffled until I ask you to move it, and then you're not. You also understand what the responsibility is to some degree at this point regarding the sobriety court, correct?
Yes.
And knowing all that, you still want to continue with your plea?
Yes.
Okay, you're muffled again.
Yes.
Okay. And any immigration issues, counsel? You're muted, Ms. Strauss.
Sorry, no, Your Honor.
Okay. And sir, has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, would you please want to hear your client?
Yes. Mr. Davis, on July 9th of 2023, were you at the location of Biddle Avenue and Miller Street in the city of Wyandotte?
Yes.
And that is the county of Wayne.
Yes.
At that time, were you operating a motor vehicle
Yes.
and you were stopped by the police?
Yes.
You knew they were police officers?
Yes.
And did they ask you to step out of the vehicle at any point?
Yes.
And you refused to do so, is that correct?
No.
Did you disobey a lawful command from an officer?
No.
Mr. Davis, at the time that you were asked out of the vehicle, were you asked to complete sobriety field tests?
Yes.
And after those sobriety tests, the police officers tried to place you under arrest. Is that correct?
Yes.
Okay. And you resisted that arrest by slamming your head into the car. Is that correct?
No.
Mr. Davis, did you slam your head into the car, the police car?
When I was in the back of the car in handcuffs already.
Okay. And the officers told you to stop doing that?
Yes.
And you did not stop, is that correct?
I stopped and then they maced me.
Really?
Okay.
Counsel, would you like a breakout room with your client?
Yes, please.
Okay, we'll go off the record and we'll recall this matter in just a few moments.
Thank you.
It'll be breakout room 3. Mr. Davis, please join breakout room 3. Okay, we are going back on the record the matter of John Davis. All right, and counsel, if you'd like to continue with your board here.
Yes, Mr. Davis, where we left off, you indicated that you're sitting in the back of a police car. Is that correct?
Yes.
And you were hitting your head on the car?
Yes.
Okay, and the police officers asked you to stop. Is that correct?
Yes.
And you did not stop.
Correct.
Ultimately, the officers had to pepper spray you to get you to stop. Is that correct?
Correct.
Okay. And when you were operating that motor vehicle, a Dodge Ram, had you ingested any alcohol at that point?
Yes.
And what alcohol did you ingest?
Liquor. Tequila.
And you would agree with me that it impaired your ability to drive that vehicle. Is that correct?
Yes.
Okay. And you were taken to the hospital where you had blood drawn?
Yes.
Okay. And Judge, I would stipulate to the blood draw being at 0.158 grams. And I'm satisfied with the factual basis for both charges.
Okay, I show 0.23, so let me just confirm, that was just a note I had from the police report from the DBT. All right. 0.158. Will be stipulated. All right. And the court will indicate that the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charges, dismiss the original charges per the plea agreement, so long as you're accepted into the 19th District Court Sobriety Court. And counsel, we will schedule this matter for sentencing on November 16th. That's 3 weeks from today. That should be sufficient time.
Yes, Judge, that'll work.
What time works, counsel? Does 8:30 work?
Yes.
Okay. All right, Mr. Davis, you still have the alcohol tether on, correct?
Yes.
All right. And if you were to test today, would there be anything detected in your system?
Not anything besides my prescriptions.
All right. Bond conditions are continued. Please make sure that you are staying in contact with the 19th District Court Treatment Court Probation Officer. But I'm going to also have you email in Ms. Shaw, because she's been the one that's been communicating with Ms. Brandenburg from the 19th District Court. And so please email in Ms. Shaw by 10:15, okay?
Okay.
All right, thank you very much. Have a good day.
Thank you, you too.
All right, thank you.
Is sentencing set for in person or?
In person, yes.
In person? Okay, thank you.
Thank you. Have a good day.
You too.
Thank you.
All right, thank you. All right, and this is the matter of the state of Michigan versus James Mitchell, 232242. And appearance, counsel?
William Glenn, P3679, on behalf of Mr. Mitchell.
Thank you. And Mr. Mitchell, can you please unmute? All right, and Mr. Mitchell, can you please state your name for the record?
James Arthur Mitchell. Your Honor.
Today's date scheduled for the probable cause conference. Mr. Glenn,
Your Honor,
today's-
Your Honor, I've spoken with my client. He understands that he has a right to a preliminary exam where it must be shown that a crime was committed. There's probable cause to charge him with that offense. Understanding that he wished to waive his right to a preliminary exam and be bound over to the Wayne County Circuit Court on the charges and the complaint warrant. Is that correct, Mr. Mitchell?
Yes, sir. A little nervous this morning.
That's okay. That's all right. And sir, you heard everything that your attorney indicated, correct?
Yes, Your Honor.
And you understand that you do have the right to have a preliminary examination where it must be shown that a crime is committed, probable cause exists to charge you with that crime.
I understand that.
And you also understand that by waiving your right to a preliminary examination, you will be bound over to circuit court for further proceedings on the charges and the complaint warrant.
Yes, I understand that, ma'am.
And you have received those charges in the complaint warrant.
I believe so.
Well, you received notice of those charges. You understand what you're charged with, sir, correct? And the possible penalty?
I believe so.
Okay. Has anybody promised you anything, threatened you, coerced you in any way for you to waive your right to your preliminary examination?
Yeah. Could I make a brief statement, Honor?
Well, hold on, sir. Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No, Your Honor. No, they have not.
Okay. The court will note that examination having been waived, defendant is bound over to circuit court for further proceedings. You are to appear in Circuit Court on November 2nd at 9 a.m. on the charges of the complaint. And what is it that you wanted to say, sir?
Yes, Judge DeSanto, I just wanted to say I've been a resident, tried to be a faithful citizen of Wyandotte for the past 13 years.
That's not true. You're so full of baloney.
And I've lived there most of my life since the early 60s. My former father from 1702, 1712 Electric Street at Electric and Alkali. That was where I was raised. And the only reason I bought that vehicle is because I had to find a better way of getting around. I went to that Secretary of State several times and I asked for a written exam. They kept telling me we don't do that no more. That we have to do it through the computer. And they sent me all that documentation saying that your new license will be sent. And I never got no license in the mail. It was just a license ID. And it's very aggravating to me, Judge. And I never meant no disrespect to your honor or your courtroom. It's just my circumstances due to my surgeries.
Okay.
From early childhood.
Yeah.
Okay, thank you. Counsel, let me, your client has a pending charge in this court from September 15th. Let me double check and see what happened with that, if it's still pending. Because
Okay.
I'm showing that he was sent a notice to appear for obstructing police. So let me just double check on that, okay? So we're going to go off the record. Okay, so we're back on the record matter of James Mitchell, 232242. And counsel, so I stepped off because there was Mr. Mitchell's criminal history of pending charge, and because those matters had been set for a different date in December, and upon Mr. Mitchell's arrest on this matter last week, those matters we pulled those and we handled those as well. So Mr. Mitchell, you also have adjourned pretrial dates on those other two matters for Tuesday, October 31st. So counsel, that's why I stepped off. I wanted to make sure that those had already been addressed, so we need to do the arraignment. So as the felony matter, the court will indicate bond and conditions are continued. And then Mr. Mitchell will see you on Tuesday. Mr. Glenn, are you all set or are you being spot appointed? I think that you are being spot appointed on one of our matters, no?
I have not heard anything. Your Honor, man, we have a DSU report on our case for next week.
I will refer to DSU.
Okay. If I'm appointed, I'll zoom back in, but I have not heard anything.
All right, thank you.
All right.
Your Honor, could I please say something?
Yes, sir.
Can we just do that next appointment online? Because I'm not in no condition to really be traveling right now back to the 27th District Court. So I'll take that up with the council.
Well, sir, you may, I believe you have a $100,000 10% bond, so you'll still be in custody. You'll be appearing by Zoom, yes.
I understand that.
All right, thank you.
Well, guys, I'm willing to aboard that trigger train. Choo choo! I'm speeding down the railway, about to crash off a cliff and plunge to my death, but I don't know if this time if I'm going to be resurrected. Bye! Oh, I lied.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No, no.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.